So they had no opportunity whatsoever to vote on the legislators who had done this. So this was not a valid passage of the amendment, and it was purely a matter of enforcing the state constitution. Folks may say, well, the U.S. interpreting to state how animus the
Indianapolis
state Supreme Court was the final word on it.
Jessica, Indianapolis, Indiana, Independent Line. Good morning.
Good morning. Thank you both. Thank you both, Hans and Kiki, for taking my or Mimi for taking my call. First off, I do have a quick statement I want to say before I get in my question. I'm not a fan of the Save America Act at all. My mom would have to get a new birth certificate if she she changed her name, so she would have to get a new passport and a new birth certificate to be able to vote. And that's something that we're just not able to do in this economy and afford in this economy right now. My main point, though, is I called in mostly for voting reform. I live in Indianapolis, a non-swing state. No matter who I vote for in the national race, realistically, Kamala or Donald Trump, my vote really doesn't matter, especially in the presidential race. The current system we have right now is broken and has been broken my entire life since 2004, especially as I'm trying to break up Andre Carson's seat in Indianapolis. To fix the system and possibly move away from the two-party system, I proposed NaPaVoInterCo. If you're not familiar with that, it's the National Popular Vote Interstate Compact. Roughly, it is an agreement among a group of U.S. states and the District of Columbia to award all of their electoral votes to whichever presidential ticket wins the overall popular vote in the 50 states and the District of Columbia, regardless of which ticket won more votes of their individual state district. My two questions would be, would you support the passing of NaPaVoInterCo? And two, how would it affect the presidential election moving forward, assuming that it met the required amount of electoral college votes? Thank you for your time.
Would that be legal?
I actually wrote a long paper about the National Popular Vote Plan, which in essence, if states were to adopt it, they would award the electoral college votes not to whoever the voters of their state picked as the their presidential candidate, but what the national popular vote is. I think that's unconstitutional. The only way you could do that is through a constitutional amendment. But I also think it actually disenfranchises voters. Imagine what the voters of California would have thought in the past election when a majority of them voted for Kamala Harris. If the National Popular Vote Plan had been in place, that wouldn't have mattered. The Electoral College votes of the state of California would have been awarded to Donald Trump. I don't think the voters would have been very happy about that, so I actually do not think that the National Popular Vote Plan is a good idea.
Do you want to weigh in at all on the Save America Act and the requirements for women who change their name from their name at birth?
That is a red flag that is just simply not the case. The very same kind of objections were raised when states started putting in voter ID laws, like in Georgia 20 years ago. That has not been a problem or an issue at all. And I would point out that in the SAVE Act, it actually has a provision that would direct every state to set up an administrative process so that any individual who doesn't have the list of documents that they put in that can be used to prove citizenship, they have to put in an administrative process so individuals can bring in whatever other documents they may have that can prove that. All of these same claims that people wouldn't be able to comply, like I said, were raised to try to oppose voter ID laws. None of those claims turned out to be true. Georgia, for example, Georgia, which has, a lot of people say, the strictest voter ID law in the country, their turnout rates are usually higher than those of the state of New York, which has no ID requirement of any kind.
And do you believe that this is an overstep, again, with the Save America Act, of the federal government into the elections, which are supposed to be run by states?
This is an exception to that. Why? Because if you look at the Constitution, Congress has 100% authority over immigration and naturalization. That gives them great authority over aliens who are in this country. And an example of that is a statute a lot of people don't realize. Normally, Congress can't pass rules that affect how state elections are run. You know, federal campaign finance rules, for example, on how you can raise and spend money only apply to federal candidates. They can't apply those to state candidates because that would interfere with states' rights. But federal law makes it a felony for an individual who's not a U.S. citizen to contribute money to, donate money to, or engage in independent expenditures for candidates at both the federal level, the state level, and the local level. And that's an example of the fact that Congress has overwhelming plenary authority over aliens in this country.
Omar in Brooklyn, Independent Line, you're on the air.